Hey, good morning, Nighthawks. This is Dr. H here. Today we're going to dive into Chapter 3 of our course, the legal system in the United States. And I know that some of you are, I'd be thinking, let's see, I did not sign up for a health law degree or class or what have you. Um, but here's the thing, understanding our legal system is absolutely crucial for anyone working in healthcare information management. And you might ask yourself, why does this matter to you? Well, everyday health information professionals make decisions that have legal implications. Now, whether you're managing electronic health records, handling patient privacy requests, or implementing new healthcare technologies, you need to understand the legal framework that governs your work. Hopefully, by the end of the day's lecture, you'll be able to distinguish between public and private law, identify the four primary sources of law in the U.S., explain how our three branches of government create and enforce laws, navigate the federal and state court systems, and understand how legal conflicts are resolved. Some of this you've covered in some of your maybe your poli-science courses or some of your history courses, and so hopefully this will just be a brief recovering of that information. Now, how some of the laws are classified, whether it's public versus private, let's start with the fundamental question of how are laws classified. Think of the legal system as having two main buckets, public law and private law. The key difference? Whether the government is involved as a party in the legal matter. Public law is when the government is involved. Public law involves the federal, state, or local government and its relationship to individuals and business organizations. The government is always one of the parties in these cases. Public law has two main categories. Criminal law, that is what most people think of when they hear legal case. In criminal law, the government prosecutes someone who has been charged with violating a criminal statute or regulation. For example, if a hospital employee illegally accesses patient records for personal reasons, they could face criminal charges. The case would be the state of Georgia versus employee XYZ. Notice how the government or the state of Georgia is the one bringing the case. Civil regulatory law, this involves regulatory activities where noncompliance is non-criminal in nature. Think fines, license suspensions, or compliance orders. For example, if a healthcare facility fails to meet HIPAA requirements, they may face civil penalties from the Department of Health and Human Services. Fines, corrective action plans, but not jail time. And with private law, this is when government stays out. Private law concerns the rules and principles that define the rights and duties among people and among private businesses. Importantly, the government is not a party in these disputes. For example, if one healthcare technology company sues another for patent infringement, that's private law. The government isn't involved, and it's just company A versus company B. Just a quick check here. If a patient sues a hospital for medical malpractice, is this public or private? Well, this would be private. It's between the patient and the hospital with no government involvement. Now, the four sources of law, just so that we understand how laws are classified, let's explore where the laws actually come from. In the United States, we have four primary sources of law, and they're ranked in order of authority. The constitutional law, which is the supreme authority. Constitutional law is the body of law that deals with the amount and types of power and authority that governments are given. The U.S. Constitution is the supreme law of the land. Everything else must comply with it. The Constitution establishes our three branches of government: legislative branch, which is Congress; executive branch, the president and its agencies; and the judicial branch, which interprets laws. The Constitution doesn't explicitly mention healthcare, but many healthcare laws are based on constitutional powers like regulating interstate commerce, which is how we get federal health insurance regulations. Another source is statutory law, and these are laws made by legislatures. Statutes are laws enacted by a legislative body, Congress at the federal level, or state legislators at the state level. All federal statutes are compiled in the U.S. Code. When you hear about laws like HIPAA, the HITECH Act, or the Affordable Care Act, these are federal statutes. Example, HIPAA, the Health Insurance Portability and Accountability Act, is a federal statute found in the U.S. Code. It was passed by Congress and signed by the President. Another source would be administrative law, and these are rules made by agencies. Here's where it gets really relevant for you as a future health information professional. The executive branch enforces laws enacted by the legislative body through the development of rules and regulations. These regulations are compiled in the U.S. Code of Federal Regulations, or the CFR. And here's how this works. Congress passes a law like HIPAA, but it's pretty general. Then the Department of Health and Human Services create detailed regulations explaining exactly how HIPAA will be implemented. These regulations have the force of law, such as the HIPAA privacy rule, security rule, are actually regulations or administrative law, not the original statute itself. Source 4, or the fourth here, is going to be common law, and this is judge-made law. Common law is also called judicial law or case law. It's based on court resolutions of disputes, and it varies from state to state, from one federal court system to another. The key principle here is stare decisis, Latin for let the decision stand. This means lower courts must follow the decisions of higher courts in the same court system when the fact patterns are similar. A healthcare example would be much of medical malpractice law is common law. It's developed through court decisions rather than being written in statutes. When law conflicts, what happens? What happens when different laws conflict with each other? This is called a conflict of laws, and it occurs when there is an inconsistency between laws in different states or between federal and state law. State versus state conflicts, an example would be a telemedicine company based in California provides services to patients in Texas. If something goes wrong, which state law applies? This can get complicated really quickly. Federal versus state conflicts. The supremacy clause. When federal and state laws conflict, the supremacy clause of the Constitution makes federal law supreme. State laws cannot contradict federal law. A healthcare example would be some states have tried to pass laws that would be less protective of patient privacy than HIPAA requires. These state laws are invalid because they conflict with the federal law. However, states can be more protected than the federal law requires. Many states have stricter privacy laws than HIPAA. That's perfectly legal. So, how our government is organized. Let's dive a little deeper into how our three branches of government work, especially as they relate to healthcare. The executive branch, or the enforcers, the executive branch enforces laws through the rules and regulations created by administrative agencies. The Department of Health and Human Services oversees Medicare, Medicaid, and Indian Health Service, and other entities. This would be an example of federal healthcare regulation. State healthcare regulation example would be state agencies that deal with mental health services, public health, disbursement of Medicaid funds, and hospital licensing, and much more. Each state does this very differently. So let's go on to speak about the legislative branch, the lawmakers. The legislative branch enacts laws in forms of statutes. Both federal governments and most states use a bicameral or two-chamber model with a Senate and a House of Representatives. The process would be a bill must pass both chambers and be signed by the executive, which is going to be a president or governor of a state, to become law. The judicial branch, the interpreters. The judicial branch must interpret laws and adjudicate disputes, creating common law in the process. Some of the key principles, res judicata, a matter already judged, prohibits filing the same lawsuit twice with the same parties and issues. A separation of powers and why this matters. The separation of powers limits the authority of each branch and prevents any one branch from becoming autocratic. The system of checks and balances protects our rights and ensures fair governance. Let's go on and talk about the court systems. Understanding court systems is crucial because as health information professionals, you might find yourself involved in legal proceedings, either as a witness, a defendant, or simply professionals who need to understand the court systems. The state court systems typically have three tiers. A trial court, which is the lowest tier. General jurisdiction handles serious criminal cases and large civil cases. Limited jurisdiction handles specific matters like small claims, domestic relations, landlord-tenant disputes. A healthcare example might be something like a medical malpractice case would typically start in a state trial court with general jurisdiction. From there, we would move to the appellate courts. Here, appeals from trial court decisions, they don't retry cases, they review whether the laws were applied correctly. The state Supreme Court, which is going to be the highest tier, is the final authority on state law questions. Here, appeals from appellate courts. From here, let's move on to the federal court system. It also is a three-tier system. We'll start with the district courts. The federal trial courts located throughout the U.S. handle cases involving federal law or disputes between parties from different states. From there, we have the circuit courts, which federal appellate courts. In this country, it's divided into geographic circuits. Each circuit covers multiple states. And then finally, we have the U.S. Supreme Court, the final decision maker for all U.S. law. And it only hears cases by granting certiorari, agreeing to hear the case. Most cases never make it to the Supreme Court. Federal court jurisdiction. When can federal courts hear a case? Well, federal courts can only hear cases where they have jurisdiction, the legal authority to make this decision. This happens in two situations. Federal question jurisdiction, which is the case involves federal law, including the U.S. Constitution, for example, a HIPAA violation. The other would be diversity jurisdiction. Parties are from different states and the amount in the controversy exceeds 75,000. Example, a patient from Georgia sues a hospital in Florida for 100,000. This is where diversity jurisdiction would come into play. Beyond government accreditation bodies is where we're going to move to from here. And not all requirements in healthcare come from the government. Accreditation is voluntary, and accrediting bodies don't have legal authority, but they are incredibly influential. Key accredited organizations include Joint Commission for Hospitals and Healthcare Facilities, Healthcare Facilities Accreditation Program, Center for Improvement in Healthcare, and so on. Alternate dispute resolution. Not every legal dispute ends in court. Some of the alternative dispute resolutions resolve conflicts outside the courtroom and is often less costly and time-consuming. Two primary types would be arbitration, which is a dispute that is submitted to and decided by a neutral third party outside the court system. The arbitrator's decision is usually binding. Mediation would be the second. This occurs by an agreement of the parties facilitated by a neutral mediator. The mediator strictly helps parties to reach their own agreement. This is non-binding. If mediation fails, parties can still go to court. And that is all I've got for you for this week. You'll have another brief lecture on Chapter 4. Until then, everyone have a fantastic Nighthawk Nation day, and I look forward to seeing you. If you have any questions, please don't hesitate to ask. I'm always here. Have a great day, everyone. Bye-bye.